Police get a warrant. A judge signs it. So that means the search is valid. Right. Not always. That question was addressed in R.V. Garofoli. In this case, the Supreme Court of Canada looked at how courts review search warrants after they've been issued. And the key point is this. A warrant is not automatically valid just because a judge approved it. It can still be challenged in court. So how does that work? When police apply for a warrant, they submit what's called an information to obtain, or an ITO. That document sets out the facts of the investigation, the grounds for the search, and why the warrant is being requested. The judge relies entirely on that information. So later, if the warrant is challenged, the court will go back and review that ITO. The question becomes, did the ITO provide enough reliable information to justify the warrant? And just as importantly, was the information accurate, complete, and presented fairly? Because if it wasn't, that can be a problem. For example, if important details were left out, if information was misleading, or if the grounds were too weak, the court may find that the warrant should not have been issued. And if that happens, the search can be ruled unlawful, which can affect whether evidence is allowed in court. Now, this doesn't mean every mistake invalidates a warrant. Courts look at the overall strength of the information. They may remove problematic parts and ask, is there still enough left to support the warrant? If yes, the warrant may still stand. If no, it can fail. Operationally, this means the ITO matters. It's not just paperwork. It's the foundation of the warrant. Officers need to ensure that what's included is accurate, complete, and clearly supports the grounds being relied on. Because once it's in court, that document is what gets scrutinized. So the takeaway from R.V. Garofoli is this. A warrant can be challenged, and everything comes back to what was written in the ITO. If the grounds aren't there, or the information isn't reliable, the warrant may not hold up. This is not legal advice, just a briefing on Canadian case law.